Hi, this is Kaery with Kaery Concealed in the Active Self-Protection Extra channel. And today I'm going to share with you some really good news and really unexpected news that I got regarding one of the expert witness cases that I've been working on for about 2 years now. So come on back and I'll tell you all about it.
Today's video is brought to us by Mantis. The Mantis family of products is integral to ASP staff building handgun and carbine skills and are your most economical and fastest path to improvement in your skills too. Whether you choose the X10, the Laser Academy, the Blackbeard, or use them all in concert, they will help your practice be more effective, efficient, and fun. Go check them out, pick up a unit, and thank them for sponsoring today's video.
Welcome back. Recently, I got news that the prosecutor for one of the cases that I've been working on for not quite 2 years, coming up on 2 years, but not quite, decided to dismiss the charges in that case. And this is the first time I've been involved in a case where that has happened. So I thought I'd share with you a little bit about what that's like and what that means. And what does it mean if you're charged, criminally charged for using force to protect yourself, and then the charges are dropped? What does that look like? So I thought I'd share that with you. So prosecutors, it's first important to remember that prosecutors are not going to take a case to trial unless they can guarantee a positive outcome for them, which would be a conviction. And so with prosecutors having a conviction rate of some counties, it's upwards of 99%, it is the deck is stacked against you when you have to go to trial, when you can't find a plea deal that works for you, or you're unwilling to take a plea deal. And it's kind of scary to think of going to trial knowing that the person, the state, it's the entirety of the state that's against you, that they have such a high conviction rate, a high success rate. But it's just the truth, it's the facts. So the prosecution, the reason charges were dropped, I'll read you. This is the motion in order to dismiss the charges right here. And I will read it to you what it says. It says the state of Washington versus the defendant. And it says, comes now the prosecuting attorney for the county, moves the court for an order dismissing the charges of first-degree assault, domestic violence, which first-degree assault in Washington state is attempted murder. And there would be a weapon enhancement charge with that because she used a firearm to protect herself. Against, and it lists the client name. I have changed her name to protect her privacy, but the name I've given her for this is Sharon Brooks Wilson, based upon the records and files here and upon the following certificate. And then the certificate reads, I'm the deputy prosecuting attorney in and for the county, and as such is in charge of the prosecution of the above matter. And it says the state lacks sufficient evidence to disprove self-defense beyond a reasonable doubt. And under RCW 994A.411, when considering the most plausible, reasonably foreseeable defense that could be raised, the state cannot prove the charge beyond a reasonable doubt. Therefore, it is respectfully requested that the above-named matter be dismissed. And signed by the deputy prosecuting attorney as well as the judge that grants the motion. So when charges are dismissed, they are either dismissed with prejudice or without prejudice. So in this case, the charges were dismissed without prejudice. So what does without prejudice means? Without prejudice, it's not a finding of innocence. The prosecutor can refile charges at any point in the future, and actually not at any point, as long as it's within the statute of limitations of that offense. But it just means the case is temporarily halted, but the prosecutor can refile charges. So what does with prejudice mean? And this is not with prejudice, but with prejudice means it permanently ends the case and prevents the prosecutor from charges being filed again. So this made me think a lot about, this is the first case I've ever had where this has happened. And it feels good, I gotta be honest. I wasn't even the one charged, but I'm really thankful that the charges were dropped. I don't work on a case, meaning I don't write a report for a case, or I don't make myself available. It's not that I don't make myself available. I tell them I can't help you if it's not a justified use of force according to the defensive use of force standards. And so this case, this was a mom who was asleep in her own bed in her own home in the middle of the night on a holiday weekend, and her children were also, her two very young children, early elementary age children, were asleep in their beds in the home as well. And an unwelcome and uninvited attacker gained access to the home without her knowledge and began assaulting her in her bed. At that time, she was recovering from, she'd been in a car accident about a month before and had some pretty significant injuries from that car accident. Ended up having to have surgery on her leg with rigid fixation. So she had to have some screws and pins put in her leg to stabilize her ankle. And she also had some fractured vertebrae. And she had just had surgery on that ankle about a week before. So she was not in great shape medically, as you can imagine. And the individual that attacked her was significantly larger than she was, significantly larger. And I'll share some details of that with you in another video. So the motion in order to dismiss has been filed. We know what it means in this case. It's without prejudice, which means the prosecutor can refile charges again in the future if they decide to. The legal process is definitely the punishment. This critical incident happened in November of 2022. And that night, the night of November 22nd, no, sorry, November 26th, 2022, Miss Brooks Wilson tucked her two children into bed that night. And that was the last time she saw them until she was let out of jail just recently, a couple of weeks ago. So she was incarcerated. She didn't get to see her children at all. Her first attorney that was recommended to her by some people that she knew didn't do her any favors, unfortunately. And she lost her house. She was unable to work during that time, even though she wasn't incarcerated for this whole almost 3-year period of time. Even though she wasn't incarcerated for that, for all of it, it's still extremely difficult to find work unless you have a family member or a friend that is willing to hire you, or your current employer doesn't fire you once they find out charges have been filed. It's really tough. At the courthouse, there's actually a list of businesses in the area that will hire people that are under criminal charges. But it can be really tough just to even get hired and make a living during this time. So there are a number of different sections in the report, and I thought over the next few videos we'd do a little series on this, and I'd share with you some of the different sections of a report, what's in them, why they're there, why I chose to use those things, and just kind of walk you through that process a little bit and help you kind of get an idea of what it's like. So one of the things that was important to me with this case was my job. I was charged with educating the finder of fact, but not just the finder of fact, also the prosecutor's office, possibly even some law enforcement personnel that were unable to determine if this was self-defense or not, and definitely the trier of fact. So when I teach regularly, the role of an expert witness really is that of a teacher. I'm not telling them that this was a justified use of force. I'm not telling the finder of fact that. I am just saying, here are the defensive use of force standards, and here are things that go into that decision, the totality of the circumstances, everything that surrounded the individual at the time, what options they had, those sorts of things. When I teach regularly, just when I'm teaching people how to protect themselves and those they love, or we're just talking about firearm selection, whatever it is, I like to do things, I like to show rather than tell. I like to set things up so that my students can discover things on their own, because I find I learn better that way and adults learn better that way as well. So this report contains, I believe it is 37 tables in this report. And what's a table? Well, a table is just a figure, or sorry, I don't mean table, I mean figure. 37 figures in this report. And here's an example of a figure, and it is this. And it's just simply a picture of, you can see who that is. And this case involves an extreme disparity of size. The attacker outweighed the individual by over 100 pounds and was significantly larger. But that was a picture of Shaquille O'Neal and Simone Biles standing next to each other. Simone Biles is an amazing, she's an Olympian, she's an athlete, and she's very strong and very capable. But placing her against someone that is very tall compared to her makes that very difficult. Another example of a table that I used in this report is, where'd it go? I think this is it. This is from the Washington State Criminal Justice Training Center's training materials. And this case involves an attempted weapon takeaway. The attacker lunged to take away uh, the client's firearm, and I thought that it would be helpful to show the trier, or yeah, the finder of fact, or I thought it'd be helpful to show them that the method that the client used is the same method that's taught at the Washington State Criminal Justice Training Center. And when they teach police officers and security guards how to protect against a weapon takeaway. And so there's quite a bit of information in this report about why a weapon takeaway why weapon retention is important and what typically happens when somebody takes a weapon away from a police officer, let's say, that's trying to protect themselves or protect the public. And so figures, I think help a lot, no matter what. It just helps show rather than tell what's going on, especially in the age that we live in today. So I enjoy using pictures to show what's going on. I mentioned already that my role is just to educate. That's all. All I'm doing is saying, here are the standards, here are the parameters of a use of force encounter, or the defensive use of force standards. Here they are, and we'll outline those in an upcoming video. The preamble is a very important section of this report. It's not that long. The preamble for this report is about 8 pages long, but here are the topics that are covered in the preamble. Firearms are normal, and normal people own firearms. And if you know Professor David Yamane, that quote comes from him. Self-defense is not common sense. Unarmed does not mean undangerous. Defensive display of a firearm to deter an expected attack. Evaluating claims of self-defense. Considering human factors research to inform analysis, and then other relevant issues. So those are the couple of topics that are talked about in the preamble. The preamble is just kind of giving the reader just a little bit of background. For example, self-defense is not common sense. I had a case where I wasn't allowed to testify in the case because the judge and the prosecutor believe that self-defense is common sense. And there's really nothing common sense about self-defense, especially when you talk about the legal aspects of it. So anyway, that's what's in the preamble. And it's highly unlikely that a jury is going to see my report, but the judge will for sure. One of the reasons that I like to use a lot of figures and show things like that thing from Washington State Criminal Justice Training Center about an attempted rifle takeaway and how to protect that rifle from being taken is that sometimes the table or the figures can become demonstrative evidence in court. You can blow them up and make posters out of them for the jury to see. And that can be helpful because oftentimes some of that demonstrative evidence they're allowed to take back into the deliberation with them when that part of the trial is over. One of the reasons why juries are typically not allowed to see expert witness reports is because there is likely going to be evidence from discovery that is in that report or talked about in that report, evidence that the judge decides to not allow into the trial. And because of that, that's why they often won't allow the expert's report in its entirety to be released to the jury, especially, either side. They're not going to allow that. So in this series, we'll do a couple more of these videos, but in this series, we'll get into the down and dirty details about disparity of force. What is it? Why is it a factor? This case involves 8 different factors of disparity between the attacker and the defender. 8 different factors of disparity. Typically, the courts like to see at least 2 factors of disparity, but 8 factors of disparity is beyond anything I've ever seen. The only other case I've had even close to this with disparity factors is 6 factors of disparity. So we'll talk about disparity of force. We'll talk about the use of force standards. We'll talk about what the standards are for use of force regarding state, local, and federal law enforcement. Are their standards the same as use of force standards for private citizens? That's worth thinking about. Not that as a private citizen, I'm going to be chasing after somebody or trying to arrest somebody or go hands-on with someone, but what are the standards? When is it acceptable to use lethal force? Again, we want to avoid that if we possibly can, but what do the standards say? And then we'll talk about some myths regarding use of force, and we'll do that in the next section. So I look forward to seeing you next week.